Breaking news just in: court frees 24 IPOB members after 4 years of detention. Good morning, good afternoon, good evening, wonderful people, lovers of freedom all over the world. Wherever you're joining us from today, you're highly welcome to this wonderful YouTube platform that gives you quality news and information on everything happening in Biafran territory. Yes, I came with a very good news today. Proud of you hours to the final judgment of Mazi Nnamdi Kanu, which will be a historic one. The good news is already coming in. The zoo knows that they've been defeated, and every country is looking forward to tomorrow's case, which will be coming up in few hours. We'll be giving you back-to-back information on that. But the news coming to us currently, as I'm talking to you, is that the Federal High Court in Ebonyi State has released over 24 members of the indigenous people of Biafra that have been held for over 4 years. It is a very big news, a big one at that. Now let us give you this news in detail as the matter take come to us straight up. The news. A high court in Ebonyi State has ordered the release of 24 members of the indigenous people of Biafra, IPOB, after they were held in detention for 4 years. The ruling on Thursday marks a significant development in the ongoing legal proceedings involving the group. The 24 IPOB members were discharged and acquitted by Justice I.P. Chima of Ebonyi State High Court. It was gathered that they were among the last batch of the IPOB detainees out of the 36 held since May 4, 2020. Meanwhile, their lawyer and human rights activist Ifeanyi Ejiofor confirmed their freedom in a statement titled "Justice Delayed but Never Denied." I hope we'll be getting the same information concerning Mazi Nnamdi Kanu later today. According to him, the ruling followed the preliminary objection, which highlighted the brazen violation of their fundamental rights, particularly the constitutionally guaranteed protection against double jeopardy enshrined under Section 36(9) of the 1999 Constitution of the Federal Republic of Nigeria as amended. Ejiofor said the sacred principle auto fois acquit stipulates that no person shall be tried again for an offense in respect of which they have previously been acquitted. And that is that on this important information. It is a good one. And let me tell you, that news is trending currently. It is trending currently. Yes, because a lot is going to come out from this news. But I want to read a very brief article. And I want you to listen to this particular article because the zoo will be on the spotlight. For the whole world to see their, atrocious way, their corruption. If they miss it, by keeping Nnamdi Kanu still in detention, there will be a lot of problems. I can assure you that. Forget about what you've known and how you've known the zoo, and how other international communities have failed to participate in the issue of the zoo government and the activities of Mazi Nnamdi Kanu's court trial. Forget about how they've been handling it. But the reality is that something good is going to come out tomorrow. I can feel it all over my body. Yes, and I will be here to be the first to break the important news concerning the immediate release of Mazi Nnamdi Kanu, because I know fully well that he will be released tomorrow. So there will be a great shout of joy in Biafraland. Please anticipate, because we'll be giving you that information back to back. Now let us go straight up to this important information. As IPOB have said, Nigeria is on a global spotlight because the world will be watching and will be waiting for that final judgment in few hours. The indigenous people of Biafra, IPOB, has reminded the Nigerian judiciary of the implication of not adhering to a fair trial of its leader, Mazi Nnamdi Kanu. Spokesperson of the group, Emma Powerful, in a statement released to journalists, noted that the judiciary should be wary of the Kenyan High Court verdict as it comes as its trial of Kanu. Powerful said, at this pivotal juncture in the political and legal persecution of our leader, Mazi Nnamdi Kanu, it is necessary to remind the bench, particularly the Honorable Court of Justice Omotosho, that the world is watching. With the recent courageous judgment of the Kenyan High Court declaring Mazi Nnamdi Kanu's abduction and extraordinary rendition illegal under Kenya and international law, there is now a renewed global spotlight on how this case is being conducted in Nigeria. He went further. In his words, he said, the elephant in the room, which the federal government and its legal agent desperately avoid addressing, is this. How did Mazi Nnamdi Kanu come to be before a federal high court in Abuja for alleged offenses purportedly committed in the United Kingdom and Kenya? This is a very critical question. You know that injustice, is one watchword of the zoo. But this time around, one thing I can promise you is that they are not going scot-free in this one. Emma Powerful went further to say in his words, the fundamental doctrine of double criminality enshrined in Section 76 1D 3 of the Terrorism Prevention and Prohibition Act 2022 strips this court of jurisdiction unless the Nigerian government can establish through the competent court in Kenya that the said offenses are also crimes under Kenya law. This is the legal threshold that must be crossed before Justice Omotosho can even contemplate entertaining the substance of the so-called charges. Instead, we are confronted with a judicial absurdity, one that calls into question the integrity of Nigeria's legal system. A man abducted at gunpoint, tortured, and smuggled into Nigeria in blatant violation of local and international law is now expected to answer to charges before a court that refuses to ask him the only question that matters. By what law and process did he get here? Powerful queried. He continued, attempt to lean on the Supreme Court's controversial ruling, which remitted the matter to the High Court, is a constitutional dead end. The Nigerian public and international legal community must now ask, on what Nigerian law did those justices base their decision that condones cross-border criminal abduction and torture? None. The truth is, no law in Nigeria supports abduction from foreign jurisdiction and forced presentation before a court without recourse to extradition to the satisfaction of the double criminality requirement. Let us also remind this nation of the case of Mohammed Diko. I remember that, he kidnapped from Niger Republic and rendition to Nigeria in violation of due process, in a ruling that still stands as a locus classicus. The Supreme Court of Nigeria held that no one should be kidnapped abroad and brought before a Nigerian court. Let me even, finalize this thing, because there is no need going deeper and deeper with so much grammars, clarifying something that is, real for everybody to see. The fact still remains. No matter how you want to look at it, no matter how, from any view, from any point whatsoever, you want to look at this high level of criminality, the fact still remains that Nigeria committed a crime against Mazi Nnamdi Kanu from every ramifications of the law, both locally, both internationally, both domestic. Anyhow, if there is any extra law, let me know. That is just the truth. That is the fact. In fact, he has no business being tried, in this whole case. Mazi Nnamdi Kanu would have been long to release. Everything is pointing against the Zoo government. But the big question is, will they continue, will the judiciary continue in its illegality, or will they stand out for once and speak the truth through Justice Omotosho? It is a very critical, issue or decision or verdict, as the case may be tomorrow. But one thing is assured: a verdict and a judgment will be given concerning Mazi Nnamdi Kanu, and we'll be here to break that information. Please go to the comment section and give your own input concerning this matter. Please make sure you share and also remind someone that they should stay tuned, because we'll be giving you the information of Nnamdi Kanu's court trial tomorrow. God bless you.